So on the record, in the matter 26 CF 47, State of Wisconsin versus Kevin Strenky. The state appears through District Attorney Kevin Schmidt in person. We have Mr. Strenky in person in custody with counsel Joel Feliski. We're set today in this matter for a plea and sentencing hearing. Mr. Feliski, is this proceeding as such?
That is correct, Your Honor. The parties have reached an agreement to resolve here. Mr. Strenky has agreed to plead to count 1 of the complaint as amended to a charge of misdemeanor obstruction, with count 2 being dismissed and read in. The parties are making a joint recommendation for court costs only. I have completed and filed a plea questionnaire with Mr. Strenky, Your Honor, and that's been filed in the case as document number 17.
Okay, thank you. All right, Mr. Strenky, did your attorney go over with you that plea questionnaire waiver of rights document?
Yes, Your Honor.
And did he go over it thoroughly with you?
Yes, Your Honor.
Essentially word for word?
Yep.
And that's the agreement that you've reached with the state?
Yes, Your Honor.
Mr. Schmidt, formal motion to amend to a misdemeanor obstruction?
So made.
Granted. You did sign that document, you said?
Yes.
And you are pleading guilty to an obstruction. You're 42 years old. You have 11 years of schooling. You do not have a high school diploma or equivalent, but you can read, write, and you understand the English language.
Yes, Your Honor.
No drugs, no alcohol, no mental illnesses or disorders or treatment for them.
Nope.
Did your attorney go over with you what the state would have to prove your guilt beyond a reasonable doubt?
Yes, Your Honor.
Did your attorney go over with you the maximum possible penalties you face?
Yes.
Because you're charged with crimes, you are entitled to constitutional rights, and each of those rights is listed on that first page. Did your attorney thoroughly go over those rights with you?
Yes, Your Honor.
Do you understand them completely?
Yes.
Do you understand that by pleading guilty, you're waiving and giving up those rights?
Yes, Your Honor.
You understand that, or actually, do you need me to go over those rights with you in any more detail?
No.
All right. Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes, Your Honor.
You understand here the state would have to prove on or around April 27th, 2026, you obstructed an officer. The officer was doing an act in an official capacity and with lawful authority, and you knew that officer was doing an act, and you purposely and intentionally obstructed the officer.
Yes, Your Honor.
You understand the maximum possible penalty could be a fine of up to $10,000 or 9 months of incarceration or both.
Yes, Your Honor.
You understand that there is an agreement here reached between the parties, which your attorney did state on the record, but do you understand that I'm not bound to follow that?
Yes, Your Honor.
Which means that I could sentence you all the way up to that maximum possible penalty if I thought it was warranted.
Yes, Your Honor.
Do you still wish to proceed and enter a guilty plea?
Yes.
Now, did your attorney go over with you the criminal complaint? And in that criminal complaint, that's the basis. There are allegations there of what you've done and on that day and why you were charged with the crimes.
Yes, Your Honor.
For the most part, are those facts accurate?
Yes, Your Honor.
Did you obstruct an officer?
Yes, Your Honor.
Can you tell me what you did?
I took in when he approached the vehicle. I was worried because I had a probation warrant and I wasn't thinking clearly, so I gave him I thought maybe there is a possible way that I could try and.
You lied to him, right?
Yes, yes.
You told him
yes, Your
somebody
Honor.
else's name.
Yes.
Okay.
But then he came back and I told him, I said, no, Your Honor. I just told him, I said, my ID is right here in my pocket. I said, I got a probation warrant. That's why. I said, let's get it taken care of.
All right. So your attorney went over with that with you, and based upon those statements, Mr. Feliski, may I use the probable cause statement section of the criminal complaint with the statements made by your client today?
Yes, Your Honor, so stipulated.
For a factual basis. Thank you. Are you satisfied with your attorney's services?
Yes, Your Honor.
Has anyone made any threats or promises to you for you to plead guilty today?
Absolutely not.
You're doing so freely, intelligently, and voluntarily? Do
Yes, Your Honor.
you have any questions for the court or for your attorney before I proceed?
No.
As to amended count one, possession, or excuse me, amended count one, a misdemeanor obstruction of an officer, how do you wish to plead?
Guilty.
Court will find your pleas of guilt are done knowingly, intelligently, and voluntarily. I'll find that you understand your constitutional rights and what it means to waive and give up those rights. I'll find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of count one. Count two will be dismissed and read in for purposes of sentencing. A judgment of conviction will be entered today. I know that the agreement or the recommendation calls for cost, but how many days has he been in custody?
Your Honor, he has been in custody since the date of the offense. He is currently set for a sentencing after revocation out of Polk County. I believe by today's date, you would have, excuse me. My apologies for the delay. By today's date, he would have 45 days of credit.
Thank you. Recommendation and argument, Mr. Schmidt.
I think the cost is appropriate in this. He essentially lied and gave his brother's name, I believe, in order to dodge a probation warrant. It didn't work, and he's paying the consequence with the conviction, and he's been sitting on a $250 cash fund for quite a while. So I think that this agreement's appropriate. Thank you.
All right, Mr. Flisky.
Thank you, Your Honor. As I had noted to the court previously, excuse me, Mr. Strenky is currently set for revocation in his cases out of Polk County. I have the citations here, 22 CF 29 and 23 CF 10. All that is to say, Your Honor, after today's hearing, Mr. Strenky will still remain in custody, and he will remain in custody until sentence is pronounced in those cases. I concur with the state's remarks that the conduct here is inappropriate, certainly, but in the grand scheme of things is relatively minor. Mr. Strenky gave a false name to law enforcement, and then when confronted, gave his correct identification and complied with law enforcement. All that is to say, he did not struggle, assault, engage in any sort of violent activity with law enforcement. So I think that costs here in this case are appropriate. I think the agreement overall is appropriate given the sentencing factors under Galleon, and I'd ask the court to follow it. Thank you.
Thank you. Mr. Strenky, is there anything you want to add or you want to let me know?
I just say that, you know, in no way do I take it lightly what these guys are doing out there on the roads, you know, and, you know, I don't mock them for their job that they do, you know.
Why does it seem like you're going to cry?
I mean, because, you know, they put their lives on the table every day.
Are you crying over the law enforcement? Because the whole time here, it's been seeming like you are, I don't know, timid, like you're going to.
No, I mean, it's just, I am that caring person, you know. I mean, I'll even read from the Bible, and, you know, when it talks about back in the old days, the way they went about punishing people. I mean, sometimes I just get emotional.
So you're getting emotional over what the officers do and the fact that you didn't listen to an officer and you lied to the officer.
Yes.
Okay. All right. Anything else you want me to know?
That's it.
All right. This is a pretty straightforward case. There really isn't much here. You were charged with a felony as you try to use your brother's ID. You did come clean, so, and you told the truth. So honestly, this really, in all respects, at all times, is a misdemeanor. So what the court is going to do is follow the recommendation for costs. $443 in costs and fees. I'm going to sentence you to 45 days of jail, time served. All right, you sat the time, you might as well get the time here, because the reason why you're on your way to revocation is because of this case. So might as well get the credit.
Thank you.
You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I do need your DNA. The jail will make sure that we have that. You have the right to ask for it to be expunged through a written letter to the Department of Justice. Not to me, but to the Wisconsin Department of Justice. Easy to do. Mr. Felisky can assist you, or you can Google it. It's pretty easy. When you're not in custody, and hopefully you're not going to prison or anything of that nature, are you employed?
I have a job through Masterson Personnel
Oh,
in
that's right. I
St.
think you
Croix
told me.
Falls.
Okay.
And they told me that they had a spot up here at North States for me right away as soon as they have an opening.
All right, what I'm going to do is I'm going to order $50 a month to be paid towards your fines and fees. If you fail to pay your fines and fees, not only will a civil judgment be entered against you, because you're always going to owe it, but I will issue a warrant. You could sit up to 6 months in jail. I am going to stay the first payment for a period of time because I don't know what's going to happen in Polk. So I will stay the first payment. I'm just going to say for 4 months.
Okay. Okay. Thank
Make
you.
sure you pay it because I will issue a warrant.
Yes.
All right.
Yes, Your Honor.
I think that covers everything, Mr. Schmidt.
Nothing from me.
Nothing further.
All right. Thank you. Then we are adjourned.
Thank you.
Take his case first.
We will go on the record in the matter 25 CT 46, State of Wisconsin versus Skylar Notinoki. The state appears through District Attorney Kevin Schmidt in person. Mr. Notinoki appears in person with counsel Nicholas White. We're set here today in this matter for a status conference. Mr. White, can you please update the court?
Yes, Your Honor. Mr. Notinoki has a new phone number he can update, which is 715-416-5572. I was able to review with him the IDIP process. He has a brochure. He needs to talk with Tessa Anderson about it. He's been saving up. He tells me that he did the AODA assessment at Aurora. They directed him to the tribal clinic for a follow-up, and he needs to save up for the 375 to actually start the IDIP. That's where we're at.
Okay. How long do you think it'll take you to save that up, Mr. Notinoki?
Say about like another week or so.
Excellent, great. So then you'll be able to contact Ms. Anderson, pay that, and get started.
Yes.
July 23rd at 2:15, have a status just to see where he is in the program. You are coming back here on that date and time?
That's right. I was looking at possibly taking a case that has a revocation hearing that I just found out it's at 2 o'clock on that same day. If I'd be able to find a different day for this.
So am I needing to move possibly the Sukow case too?
I'm hoping that we'll be able to figure something out before then.
Hopefully
but-
she'll be completed with the program.
There's a good chance there too.
All right, makes sense, perfect. I will cross that date out for you then. All right. August 5th at 2:45, you're coming back here, August 5th, 2:45.
That works for me. Wednesday afternoon.
2:45. Okay.
All right, we will see you then.
They'll print the notice hearing. If you just want to grab that, just give me a call and send me some progress. Okay. Your Honor, then I also have Rita Wenzel here.
Ms. Wenzel, record in the matter 26 CT02, State of Wisconsin versus Kenneth Sowens. The state appears through District Attorney Kevin Schmidt in person. Mr. Sowens appears in person without counsel. We're set today in this matter for a status conference. Mr. Sowens, you had some things to pay up in Minnesota and you were working on that so you can work towards your license. Where are you in that process?
To be honest with you, I didn't make it any farther at all. Just, I ain't even got an excuse.
Do you know when you think you can have it done?
To be honest with you, no, I don't. I can't set a day like because I just don't. It's kind of hard to get around when I can't drive and stuff, you know?
That doesn't help. So, I mean, the offer is to plead to the charge then for costs, wasn't it?
No, the offer in this
Here's
case,
jail.
yes.
10 days of jail?
The state would argue for 10 days. He'd be free to argue.
Okay, so the offer is plead to the charge, 10 days of jail. You would be able to argue to the court why you deserve or should get a lesser sentence or no jail time. But that is the offer.
Yeah, I don't feel like I should have to sit any jail time on it, but.
Okay, I'm setting it for a trial though.
That's
So-
fine too. I'm willing to just settle this, man, because it's getting to be a lot to just get here and deal with it, you know?
I know, because you're from Hinckley. That's a long way to get here.
Yeah,
And you take time off of doing your job and all of those things and making money so you can pay off your debt to Minnesota, so you can get your Minnesota license cleared, so then you can get your Wisconsin license cleared, all of the things.
yep. Yeah,
So
it's a
the
lot.
agreement or the offer from the state is either get your license or it's dismissed, or plead to the charge and they will be recommending 10 days of jail to the court with you free to argue for anything that you want. So those are, or the court sets it for a trial. Those are your options.
I know it's kind of a hard decision, but. 'cause
I'll give you one more little status time to decide, but those
Okay.
are your three options right there,
All right.
okay?
Mm-hmm.
So again, I'll go over them one more time. To plead to the charge with the recommendation from the state for 10 days of jail,
Okay.
and you are free to argue any sentence that you think is appropriate.
Okay.
Get your license and have the matter dismissed, or the court sets it for a trial.
Okay.
Those are your three options.
All right.
I'm going to schedule you for July 13th at 10. Okay, July 13th at 10, and you'll be able to tell the court what your decision is.
All right.
Okay,
Thank you.
all right, come get your notice and you're free to go.